This is Michael Popok, and that means it must be time for Legal AF After Dark. Donald Trump loves immunity, even though he keeps losing every time a major appellate court rules on the issue. But that hasn't stopped him from trying to argue that he's immune from criminal prosecution on the indictments charges that he stole our national security documents and classified documents. He says he's immune. Well, there's about 4 different motions to dismiss that he filed, each one equally poor. He also argues that Jack Smith was improperly appointed, that the Senate needed to confirm him, that the Senate needed to approve his budget, and the Espionage Act is very vague. He can't figure out what it means. Things like that. If you don't know what I'm talking about, watch this clip of Legal AF and you will.
Let's get into what's going on in the Southern District of Florida case. That's the federal criminal case against Donald Trump for the willful retention of national defense information, as well as obstruction of justice. Judge Eileen Cannon did not give Donald Trump an extension to adjourn these pretrial dates and deadlines. So Donald Trump had to file them at the end of last week. Donald Trump requested the ability to file a 200-page omnibus motion to dismiss indictment, which Judge Eileen Cannon also rejected and said, no, you could submit, 10 separate individual motions. Some of them were on the public docket. Some of them have not hit the public docket because there's major redactions to them. So the ones that we do have, though, Michael Popok, just show how kind of extra frivolous there are. There's about 10 of these motions to dismiss that Trump filed. Also, his co-defendants kind of filed ones as well, somewhat pointing the finger at Donald Trump, saying that they didn't really even know that these were classified documents and they were just following instructions to move boxes around, and therefore the co-defendants claim they don't have intent. But Donald Trump's essential argument, when you combine 2 of his main motions to dismiss, one was a motion to dismiss based on the PRA, the Presidential Records Act, which Donald Trump claims he can declare anything at all to be personal records. He can take government records and just say they're personal, when the Presidential Records Act expressly states you can't do that. The whole purpose of it is so that you don't declare presidential records as belonging to you. But Donald Trump's approach to this is to say no, what it really means, because Trump's getting his advice from a guy named Tom Fitton, who's not actually a lawyer, who runs the right-wing, far right-wing group called Judicial Watch, is that he can declare anything. Nuclear codes, war plans, military secrets, you name it. If Donald Trump telepathically declassifies and telepathically believes it's personal and puts it in a box, Donald Trump's argument, it is therefore his. And then he kind of layers on this another motion to dismiss, claiming absolute presidential immunity. And if he does the telepathic declassification and telepathic conversion of our government secrets and records into personal property while in office, then Trump says it falls within the outer perimeter of his official presidential responsibilities and therefore can do whatever he wants with them. I hearken back to what Special Counsel Jack Smith put in some of those briefs in the Washington, D.C. case, where Special Counsel Jack Smith said, look, under Donald Trump's logic, you could sell nuclear codes and military secrets to foreign nations and claim it's foreign diplomacy. And then I go back and think about some of those meetings that Donald Trump even had in 2017, May, when he met with the Russian leaders who showed up at the White House. People forget he shared military secrets with the Russians when they were there, and then he posted on social media, then Twitter was called, now it's called X, Twitter then, that he had the absolute right to do that. So you think about what he's arguing here now in this motion, that he's saying that, yes, I had the mens rea, I had the intent to withhold the national defense information, right, Popok? Those are all the elements of the crime, but they're mine. Those nuclear secrets, they don't belong to you, government. They're me, and those war plans, the stuff about Iran, mine. You think those are the government? They belong to me. You can't do anything about it. It's such an outrage, Michael Pope. I mean, you can't get more of a despicable argument. And then I see Axios post, President Biden uses note cards occasionally when he talks, like every politician. So your front page story, Axios, is how President Biden uses note cards. And meanwhile, and I won't even get into Donald Trump's speech at this Black Conservative Federation thing that I've done videos about and all of his other traveling fascists. I'll save that for my political takes. For my legal take, he just filed a motion claiming that he can steal our nuclear secrets and say it's his. And I don't see that on front page. I don't see it on any pages. I see it here on the MeidasTouch. It's an outrage. Michael Popok.
Yeah, it is an outrage. By the way, we all use notes. Here's mine for the show. Okay, on every topic. I mean, it looks extemporaneous, but sometimes when Ben's talking, I'll look down and see if there's a point in particular I wanted to make for the show. I like a president. My takeaway from her report was not that he's our president's in his dotage. My takeaway was, look how organized he is. He's been doing diaries and binders of every meeting he's ever attended since he's been in public office. That's a good thing. And contrasting that with Donald Trump, who they stopped giving the presidential briefing to because he was too bored, uninterested, or too stupid to get the presidential briefing, daily briefing. That is the contrast that we have here, and why people run stories about him using notes. I'd be shocked if a president went up to a podium and didn't use some sort of notes to handle all the things he has to handle. Now, putting that aside for a minute, the four motions that you talked about that we know about, two of them are just completely frivolous and ridiculous. This is the same thing that they had to do, as you mentioned, Ben, with Judge Chutkan in the D.C. election interference case. They had to do, I think it was four or five then at the time. And one of them is, special counsel was improperly appointed, can only go through the Senate. That is completely wrong. And every court, including up to the Supreme Court, has recognized the procedure, implicitly or expressly, the procedure that Merrick Garland has used for the appointment of the special prosecutor, so that he's invalid. And they don't even call him special counsel Jack Smith. At one point, they just call him Jack Smith. Jack, like he's some sort of, action hero, that Tom Cruise is going to start playing soon. Jack Smith can't, he's improperly appointed. Therefore, everything he does is invalid. Wrong. Then they didn't like that. So they said, well, let's do one on appropriations, as if they understand the appropriations clause or process under Congress. His budget, he shouldn't be spending taxpayer dollars chasing after me. Okay, that's even in the hands of Aileen Cannon, who you and I may differ about some of her actions. We all agree that she is not reliable in terms of her decision making, and we can go further as we continue on this segment. So those two forget those. That's just chaff that they threw up just to throw spaghetti at the wall, hoping that Aileen Cannon would give them something. The last two is, one, they had to do, even though it's brazen, they just lost presidential immunity on a similar argument with similar lawyers in front of the D.C. Three-judge panel of the D.C. Court of Appeals. And we'll talk about it coming up next, about what we're waiting on with the United States Supreme Court, whether they're going to leave it undisturbed or they're going to overturn it. But they already lost. Now, that is one circuit among a total of 12, including the D.C. circuit. So you can try to invite a conflict between the circuits, even while the Supreme Court has not yet ruled. And that's what they're doing. I mean, I give them an A for consistency or a C for consistency. They're like, well, we got to keep going with this immunity thing. No person really believes that Donald Trump's lawyers even believe that they have a winning argument on immunity at all. This is all about delay. And if they can get Aileen Cannon to make a bad decision again, and they have baited her in the past successfully into making bad decisions, starting before the indictment even came out, in how she interfered with the investigation and the search warrant, bad decisions leading to her getting reprimanded twice by the 11th Circuit Court of Appeals. She just recently made a bad decision, totally against the weight of the law, clear error, and manifest injustice, as we like to say in the appellate world. And now she's going to have to that just happened a week ago. So they know if they pressure Aileen Cannon, because she doesn't have the experience and her judgment seems to be slightly off kilter, her initial instincts don't seem to be there, they can get her to make a bad decision that they'll just deal with delay in time at the 11th Circuit. So the two you talked about, yes, immunity. There's no way he has immunity from Espionage Act violations, right? Because you can at the same time be a president and have committed Espionage Act violations if the indictment makes that out. And I'm going to talk about the indictment procedure for a minute here next. then so they don't like the Espionage Act. They don't like the way it's being applied to Donald Trump. Oh, it's constitutionally vague as applied to the president of the United States because he's got these other duties under the Presidential Records Act that he also violated. But the heart of the case is not the Presidential Records Act, which is not a defense to a criminal case. The criminal case against Donald Trump at its heart and soul is obstruction. That's why when they appointed the special prosecutor, special counsel, Merrick Garland said the word obstruction more than half a dozen times and never said the word Espionage Act because the case is about obstruction of justice and all the things that lead to that and conspiracies around obstruction of justice. That's the box moving. That's the hiding the documents in the boxes from his lawyers, not just Evan Corcoran, but also from his lawyers that were initially negotiating with the National Archive. It's the obstruction of misleading your lawyer so he misleads the Department of Justice and the special counsel and the FBI, while people that worked in and around Mar-a-Lago, like housekeepers and maintenance people who cooperated and executive assistants all said, there was a lot of box moving going around at the very moment when the boxes should have been turned over without objection to the National Archive. He should have just turned, if he took it by accident, which is sort of the Joe Biden, Robert Hur world. He didn't do it on purpose to the extent of criminality, wanted it for other purposes. He thought his diaries were fine. That's Joe Biden. If he did it by accident, then when you get your first demand from from the National Archive, you turn them back. And let them figure out if there's personal items to send back to you, not the other way around. But that's obstruction. So their argument that the Presidential Records Act somehow presents a defense to obstruction is ridiculous, and that is not going to be the law, or that he had classified security clearance, Q clearance at the Energy Department level in order to keep the nuclear secrets. That's completely wrong as well, and we've seen people. And we've had them on our channel that walk through the proper national security clearance need to know basis analysis, and he fails that as well. So that ain't going to work. One commentator I like said on one of the YouTube channels, "Oh, now we're just going to have Kash Patel get up and talk about the magical declassification that nobody saw and nobody wrote about at the time they left the White House. That's going to be his defense. Good luck. Even a North Florida jury, which kind of trends a little bit towards Trump politically, would convict him if that is going to be his main defense." But the reason none of this is going to work doesn't matter to Donald Trump, because his goal here is not to win on any of these. His goal is what we're watching, which is the delay. And so the reason you and I are talking on late February, almost March, about an indictment that was presented a year and a half ago, this whole thing is about what the indictment says, not what the 1 trillion pages of documents that have been delivered in discovery say, not the whole fight over SEPA, the classified information case. It's none of that. This is about the 40-page indictment that came out a year and a half ago. If they had the grounds for any of this, it should have been raised 8 months ago. And you and I should have been talking about motions to dismiss at the same time we talked about the motions to dismiss the DC election interference case, which happened around the same time. But that's when Judge Chutkan had the case, and she said early briefing, this one, Aileen Cannon, let this go to 2 months before the trial to talk about the dismissal of a piece of paper called the indictment. What does that have to do with anything? Because here's how it's going to work. She's going to set a briefing schedule. They've asked for oral argument. There's going to be 2 more briefs that have to be filed. She's not going to accelerate a darn thing. And this thing's going to stretch out through the entire month of March. She's going to make a ruling in April at best. There's going to be an appeal level up to the 11th Circuit that's going to take us over the summer. And so bye-bye trial date. And we're going to know, Ben, because on Friday, there is a hearing in front of Judge Cannon where she's going to basically say that trial in May is over. and we're going to get either a new trial date or an indefinite postponement. And that's exactly what Donald Trump has wanted. He's got his group of trials that he's tried to torpedo one by one, and he's gotten so far. He'll get this one off the board before the election. He's pinning down right, wrong, or indifferent, Fani Willis, and the setting of that trial in Georgia based on the charges against her. He wasn't able to stop the Stormy Daniels business record fraud case, which is going to trial, as you and Karen especially predicted would happen by the end of March. That submarine case that's now the number one case going to trial. And now what we're going to watch and carefully hear right here on our network is going to be this hand-to-hand combat to see if we can get the Chutkan case back up and running by the summer, depending upon what the Supreme Court does next.
Well, look, there was never going to be 4 cases that could just actually fit in, just the spacing of it before the November 2024 election. Just not possible for that to even take place, at all, unless there were overlapping trials, which would not be the case because Trump has to appear at these criminal cases. So, the thing is, if there are 2 that do take place, and the 2 that take place is the Manhattan District Attorney case and the Washington, D.C. federal criminal case for overthrowing the results of the 2020 election or attempting to, those are the 2 that I'd like to have seen. And I think Trump will have made a massive strategic blunder not to put the case first before the one that's before Judge Eileen Cannon, who's his preferred judge, who bends over backwards, who likely in jury selection and all of these other things would have been helpful to him, but also filing all of these motions before her as well. Popok, I think, has the chance of backfiring because, as I've always said, her corruption is also matched and exceeded by her incompetence. Like when she tries to be corrupt, she often even applies the wrong legal standard that's so obvious that Special Counsel Jack Smith just pulls out the seminal case on an issue and says, look, you're using the compelling interest standard. It's always been a good cause standard. You're just wrong, Cannon, in trying to help out Trump. She makes mistakes like that. So now you're going to have 10 motions, 25 pages double spaced before her on these types of issues and expect that she's not going to make gross legal errors that could eventually lead to her ouster at the right time after Trump's already going to be potentially convicted on 2 separate felony cases, the New York State case and the Washington, D.C. case. And again, let me just make this final point too. Usually criminal defendants don't like to just chill as criminal defendants, to your point, Popok, right? If they have a defense they think, I've got this great defense, I'm going to win, you file the motion to dismiss the indictment right away. You don't wait to the very last day of a deadline if your goal is anything other than delay. You want to be out of the case quicker. But again, to your point, that's never Donald Trump's goal here. He wants to delay this stuff indefinitely.
Well, that was Legal AF. We do that twice a week on the MeidasTouch network, exclusively there. You know that. Don't change that dial. You're right here already. Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. We curate the best 4 or 5 stories at the intersection of law, politics, and justice that we think you need to know. And if you like lawyers who know what they're talking about at the intersection of law and politics, you've come to the right place. We call it Legal AF. Yes, the title is exactly what you'd think. So if you know all about us and you already enjoy our show, we really appreciate you being along for the ride. Take that clip, send it off to friends and family and people in your life and say, hey, you know that show, Legal AF, that I like? Here's a clip. If you like it, come make the investment and join us for our full show. If you have no idea what I'm talking about, I'm Michael Popok. That was Legal AF, and we invite you to join our audience. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.